I think it's, the problem is details, or rather that's one of the problems, that people don't bother to report the details accurately, and so, when people are sloppy with the details, they get away with it. They're rarely picked up on it or rarely corrected. So, actually,
because they're going to say, oh, it's an accidental mistake, and like if it went to court, for slander or libel, that they'd say, oh, that was just an accidental mistake, I just misstated something. But there's so much misstating.
Yeah.
That's not an honest mistake after a while, but they get away with it because it would appear that way. If it went in front of a jury would say, yeah, that's a whatever. So it's whatever you can get away with is what they're up to. But there's no, they can't cite anywhere where I've presented a theory, or even we have Mr. Fetzer who decides my word evidence means theory on the cover of my book.
Yeah.
Yes.
Have you been on the show with George Norrie?
Are you asking me or?
Yeah, Dr. Wood, yeah. Have you been on the show with George Norrie?
Twice. Most
so he should know better then?
Right. He should know better. He says several times, but it's twice. Once in 2011, my book first came out, and he has my book. So does his producer. He has my book.
But he also said that in that particular clip, I don't know whether you played it earlier on.
Didn't play it on this show.
George Norrie actually said, "Oh, I know she's not going to like me calling it a theory." I mean, maybe that weren't the exact words, but
he says, "Oh, I don't have a theory." He mocks me.
Something like that, yes. And so he perfectly well knows that
he's incorrect.
He knows what he's doing, but yet he's still doing it. He doesn't really see.
And he's not a scientist.
No.
So how is he, judging and ruling over a scientist? But that's another strange thing that happens in this community.
But it's not, by and large, it's not a community that's got a high concentration of scientists in it. That's one observation I've come to. Or
and I can see why. It's you throw your hands up and walk off because it's so insane. I think therefore I am. The Fetzering, definition in the Urban Dictionary. I think I'm right, so therefore I am.
Indeed.
Oh dear, there's too much of that going on. But we've mentioned a lot about court cases a minute. Yeah, evidence. Shall we? Can we go through some of the court cases then?
The latest, there's a couple of, they always have different ones going on because of this issue that I'm the only one who's submitted a federal key tam case about the destruction of the buildings. And Morgan Reynolds submitted one about the assumption, the false assumption they made of, we think they were planes, so therefore there were planes. That's what his issue is about. But mine was on the fraudulent report about the demise of the buildings, and no one can refute what I presented. They dismissed the court case basically because there were only a handful of supporters, two of which are right here on your show, and that's a problem, I think, for those trying to cover it up, because they haven't submitted a court case. But they want to make people think that they have. Like when I submitted my request for corrections to NIST, that was my first action. That was March 16th, 2007. 3.5 weeks after that is when Richard Gage's website went up, and then they, along with Stephen Jones, submitted a request for corrections to NIST. But theirs didn't include any thermite. But if they hadn't submitted one, they would look like they weren't doing anything, and Dr. Wood was the only one doing anything. And I think they're still fighting that battle, but they can't afford to do anything because without any evidence.
They very rarely talk about that submission. In fact, I don't think I've ever heard them talk about it, thinking about it. They very rarely say, "Well,
it didn't work for them because of your video on it."
Well, possibly, yeah, possibly. But I think they had to be very careful because it's clear that it's clear to me at least.
To defraud the government.
Yeah, they knew what they were doing. So to anyone that actually read their document and read their website, they would know that they were acting dishonestly, and and therefore they were just going through the motions with that submission, and not really, there was no meaning to
be
it,
pots
really.
and pans to drive people away from looking at what I was presenting.
Yeah, exactly, yeah.
Well, do you remember what happened when you wrote the press release, announcing that I had submitted this and making noise about it? You remember what happened right a few minutes later? Well, actually, within a few hours, Stephen Jones announced this new whistleblower come forth with the floor plans of the World Trade Center.
I don't remember the timing of that.
That was like within a day. It was a matter of hours.
Yeah.
And now we can finally figure out what happened, because we now have this whistleblower that came forth, and then all this hoopla went rippling through the truther community to rally behind it. So they weren't looking anywhere else. They're looking for, where can I download the floor plans? Well, they call it the blueprints, but it was that's blueprints for truth. That's where that was coming from.
Yeah.
And it was really just the floor plans. Yeah. But they present them as the blueprints.
What was the outcome of their court case? Did they just get thrown out?
They didn't have a court case. Wait, back then. So, but they're trying to give the impression they have a court case. So they had this NYC CAN thing. They were getting everybody's signatures on it. So what that does is get people to sign on. Once you've signed on, you're more invested, and you want to see something go forward. You want to be on the winning team, right? So you're not going to abandon something. So they're collecting signatures to get see how many people we have. And I think it was to get something on the ballot, to vote for something, to maybe think about doing something about getting a new investigation. But there was nothing about any evidence.
No termite, no nothing.
No, nothing. It was just about, do they have enough legitimate signatures to get something put on a past inspection to get put on the ballot, and it failed inspection, so they went out and got more signatures. And then they still didn't have enough signatures, and so they were taking it to court saying, we do too have enough signatures, and back and forth. It was nothing to do with the buildings.
Okay.
And then finally they decided to abandon that. Now they have a new one. They're passing the hat and wanting people to donate. They don't have enough money to get a lawyer to do a FOIA request. And so they're passing the hat for, they need to come up with $8,000. Well, they have, $640,000 ad campaign that they came up with that money overnight to put big electronic billboards on Times Square. So I want them to get, they don't have a problem getting money.
No, they don't.
And
I think I read somewhere that they made $2 million between there's up to 2000,
2008 to now. Yeah, or 2008 to now. But that's above the table. You don't know how much they have below the table.
Oh yeah.
But what is their objective? And they say they need to hire a lawyer. That's what the $8,000 is for. AE 9/11 Truth has how many lawyers in it?
There's at least one we know of. But
yeah, James Gorley, who's written hit pieces about my work, distortions of my work. And before, Richard Gage said he couldn't submit a legal case because he's not a lawyer. Well, I'm not a lawyer.
No.
Exactly.
So how exactly did they throw your case out? What were the wording? What did
Well, they
say?
didn't throw it out. They didn't throw it out. They dismissed it. That's throw out is a kind of a derogatory term, as though it's nonsense, and it was not nonsense. They acknowledged that the law applied to my case, but in order to dismiss the case, they had to ignore the law. And now I am speculating, but I think it's pretty good, easy speculation there. They didn't state it, but I think it's pretty clear that if there's only 5 people who support the case, if it goes forward, the defendants are members of the military-industrial complex. And so there's only 5 people who support the case. What's going to happen to the judges if they, let this case go forward? Are they going to get justified on the way home from work that day? That won't help.
Oh.
That won't solve it.
I mean, to mention the order of things, what happened was it went initially into the court of the Southern District of New York, SDNY, and the judge for that initial submission was George Daniels, was it, I think?
Yeah.
That was his name, wasn't it? And you can you can read the ruling that he wrote, because there were actually 3 submissions at the same time. There was Dr.
No, they weren't at the
Wood's,
same time. They were they're like,
well,
yeah, Morgan's was submitted more than a month after mine. Month and a half, 6 weeks after mine. And
so did they rule on them at the same time, though?
They did. They ruled on them at the same time. They weren't submitted at the same time, but they ruled on them at the same time.
Yes, okay, so that's maybe what I should have clarified. So they ruled on them at the same time.
They ruled on them in one document.
Times.
Yeah, they used one document.
One single document. I think they just copy and pasted the details of the plaintiff at the top of the case, pretty much, didn't they?
Yep. I was kind of criticized for not having any evidence of no planes, but that wasn't an issue in my case. And I was also criticized for saying that the military did it. I was also criticized for saying I didn't have proof that bombs did it. Well, that wasn't my issue. That was Haas's issue about bombs in the building, and his issue was about Building 7.
So well, they won't. Nobody will know who Haas is, so we have to explain that. And that was the 3 cases that were submitted, or should I say, the 3 key term actions that were submitted were Morgan Reynolds, which primarily focused. Yeah, and then there was Ed Haas, who had a website called muckrakerreport.com.
His was not a key tam case.
Okay.
His was just saying that he didn't want, he was warning NIST not to commit fraud by issuing a report about Building 7 because he suspect they're going to, commit fraud.
Okay.
It was something like that, and it was to stop action, and it was so it was a totally different type of thing.
Oh, I see, which even makes the ruling even more unusual than that they should use the same ruling for that case as well, or the same document, even though it was a different action. It wasn't
a different case about a different building. It was the only thing in common was that it was an event that happened. The original event happened on 9/11. That's the only thing in common.
And the thing that stood out in my memory of that was if you read the ruling, it mentions that something along the lines of, I'd have to go and get the actual document. I don't know if I've got it to hand now, but the document mentions the moon landings and JFK.
Yeah. In my thing, it says he's not going to hear a case about who shot JFK or what landed on the moon. That's not the exact words, but it's pretty close. Yeah, and it wasn't what the case was about. He must have misunderstood my case when he read it, assuming he read it.
So you appealed and went forward. Did the other people appeal there?
But there's another thing. The lower court also said that I didn't have a whistleblower status because he decided he wasn't going to read my whistleblower report, which was the request for corrections to NIST. He decided to just omit mentioning that, so then he could say I wasn't a whistleblower if he didn't mention my act of whistleblowing. And so that was another issue he did. And to qualify for a PTM case, you have to be the first whistleblower about this issue, and you have to show there was fraud. Well, that's pretty clear. But what was happening is that the courts were, misapplying the law or misinterpreting the law, and it was spinning so far out of control that they were saying, well, you had to show premeditated intent to commit fraud and exactly where they were standing, exactly where the minute hand was in the clock when they were, pre-planning to, what was in their mind at the time. It's something you couldn't possibly do. It was ridiculous. And this was around the time they were doing all these bailouts in Congress, and Congress wanted to put a a way to track and keep fraud from happening. and allow whistleblowers to come forward. And so they did a restatement of what the intention of that original law was. They called this the Fraud Enforcement Recovery Act, which was a restatement of the original thing, that the person coming forth, the whistleblower, just needed to show that they were a whistleblower, the first one. I'm still the only one, about the issue I brought forth.